If the government break a manifesto promise, can you sue them? Well, the short answer is no, you can't. However, that has not stopped people trying, and also it hasn't stopped the Law Commission looking into whether you should be able to. So let me give you a bit of background first of all. Politicians make all sorts of promises, don't they? But particularly during election time or before referendums. They'll publish their manifestos, or you'll all remember the Leave campaign, £350 million to the NHS bus. If they don't deliver on that, what can you do? Well, how would you normally enforce a promise through the courts? There are three main ways. You've got contract, detrimental reliance, and legitimate expectation. Now, I won't go into massive details about contract law. Maybe I'll do a video at some stage, because it's quite an interesting subject. But generally, for a contract, you have to have offer, acceptance, consideration, and the intention to create legal relations. So what's the offer? The offer effectively is, if you vote for us, we will do all these wonderful things for you. How do you accept that? Well, you can accept by performance, just by voting for them. It's the same way that if somebody puts a poster up saying, lost dog, I'll give £50 to whoever brings my dog back, you can accept the contract just by bringing the dog back. There's a famous case, Carlil and Carbolic Smoke Ball, which is all law students are familiar with. And that was one where somebody put an advert up saying, use our product and we guarantee you won't get the flu, and if you do get the flu, we'll give you 100 quid. And later 200 quid. And here's a letter from our bank saying the money's in there. Somebody used the smoke ball, did catch flu, sued them. They said, oh, come on, that was just an advert. The court said, no, that was a contract which they accepted by buying your product. Pay up. So what would the consideration be? Consideration is something has to change, a value has to change both ways. So, the consideration on behalf of the politicians is, we will do all these wonderful things. But what's your consideration? Well, it's just voting for them, isn't it? So can you bring a claim in contract, for breach of contract? Or, misrepresentation. I would not have voted, I only voted for you because you said you'd do all these wonderful things. I mean, that's the normal contractual remedies. But it's one of these really weird things. It's a bit like how adverts normally have to be legal, decent, honest and truthful, but political adverts are explicitly excluded from that as a matter of law. Strange that, isn't it? It's almost like, who makes the laws? So a claim in contract, while theoretically possible, doesn't seem to be a runner. What's the other one? Detrimental reliance. Because somebody has actually tried this with a breach of a promise by a politician. Let's say somebody promises to do something for you, and it's just a promise. They don't want anything in exchange. So say, for instance, you can't afford your rent, so you say to your landlord, I've got to move out, and your landlord says, well, no, that's fine, just stay in there, just pay what you can, or I'll accept half rent. Well, there's no real contract there because there's no consideration. You have not actually given anything of value in return, in fact, because you're better off. But let's say the landlord down the line sues you and says, well, look, there's no contract there, so I'm allowed to sue you for the balance of the rent. Well, if you can show a detrimental reliance on that promise, then that will defeat the claim. So if you say, well, had you not have made that promise, I would have actually gone looking for somewhere cheaper, and I would have found somewhere cheaper by now, and I'd be all settled and established. So I have acted to my detriment based on what you promised me, and that's a defence. Now, the thing with promissory estoppel, and there's various types of promissory estoppel, but they all basically boil down to, you have acted against your own best interests in exchange because somebody told you something. They promised they'd do something. Normally it is a shield, not a sword. In other words, it's a way of defeating otherwise proper legal claims. But you can't usually in this jurisdiction bring a claim yourself on the back of it. But there have been exceptions. A lot of cases where, for instance, people have agreed to work for sort of, peanuts or no wages at all, on the promise that, a farm would be left to them in the will. And the courts actually then, when, the farm hasn't been left to them, it's just been left to the relatives, they generally speaking, they don't actually say, yes, you get the farm. They won't overturn the will. But what they will say is, however, the beneficiaries of that farm, you now owe this person like 10 years' wages or 20 years' wages, because that's an equitable remedy. I mean, theoretically, they could just say, no, we're going to overturn the will and give you the farm. But what they generally tend to do is, okay, we will compensate you by money just because that is easier. And what's legitimate expectation? Legitimate expectation is one of the grounds for bringing a judicial review. So that's a claim against a public body or quasi-public body. And the argument there is that you had, as I say, a legitimate expectation that they would do something, they would deliver on something, and they have failed to do so, so you can bring a claim on the back of that. Now, interestingly, this was one of the times somebody sued the government. There was a young lass, and she was the beneficiary of some education scheme. But the incoming government said, we're going to abolish that scheme. However, we will allow anybody who's already signed up to it to stay on it. We will actually fund them. But when they got into power, they actually reneged on that promise. So this lass brought a claim, and she said, look, I had a legitimate expectation that I was going to be funded. I mean, arguably, she could have possibly run a promissory estoppel type thing as well by saying, look, had I have known that you were going to renege on this promise, then I would have sought other funding, or I would have, chosen a different career path or a different course or something like that. And in that particular case, it was quite a strong one, because they had actually sent a letter to another parent saying, yes, we will fund your kid. But because this lass hadn't actually received a personal letter, the court said it's one of these things where it's a political decision, and we are very reluctant to interfere with political decisions. However, if she had had a personal letter saying, yes, don't worry, your place is safe, that might well have gone a different way, because although it's hard, just to enforce promises made willy-nilly to the general public, if a government body makes a promise specifically to you, then arguably that creates a special relationship, and like I say, this concept of legitimate expectation. So that came pretty close. But what about general manifesto commitments? Somebody actually brought a claim. It was the government had promised a referendum on some sort of thing to do with Article 50, and it was all to do with some like EU type shenanigans. And another politician from a rival party, when the government didn't, give the referendum they had promised, he brought a judicial review of that, and he said, look, I personally and the public at large had a legitimate expectation of a referendum. And the court looked at all this and they said, yeah, the trouble is it's a political decision, and ultimately Parliament is sovereign, so they can pretty much do what they want. But the courts do take into account manifesto commitments. Say, for instance, you want to bring a judicial review against a government policy. You say this policy is unlawful, or it's irrational, or it's in breach of some other laws or something like that. Those claims succeed all the time. Usually, though, they will say, well, actually, government, you have set the rules and you're not actually following your own rules. But one exception to that, where they just blanket won't interfere, is with manifesto commitments. So say, for instance, the government, a party says in their manifesto, we are going to, round up all your firstborn children or something like that, something ridiculous. And you say, well, that's clearly an unlawful policy when they're elected. Courts generally say, well, no, because of the fact that was an express, political commitment in a manifesto, we're not going to interfere with it because we can't overrule the will of the electorate. So that's the sort of basic principle. And like I say, with this, the claim on the bus, for instance, people did disassociate themselves with that and sort of said, oh, well, it wasn't my idea, etc., to avoid being sued. Now, the Law Commission looked at this and said, generally speaking, there is this idea of misfeasance or malfeasance in public office. Does it amount to that? And they said it causes all sorts of problems though, because, first of all, what's the nature of public office? What's the nature of the promise? And they said pragmatically, parties would easily get round it, because instead of saying, we will, fund 20,000 extra nurses or 20,000 police officers or build all these hospitals, all they have to do is frame it in terms of, we will aim to do this. So they said all it would actually do in practical terms would just make people a lot more nebulous in their manifesto commitments. I mean, we have this now in advertising. You have what they call mere advertising puffery. I mean, certain beers do not have to be probably the best lager in the world. Certain butters might not be the actual finest, because, they're just nebulous terms. There's a great thing actually in one of the Highline stories, The Man Who Sold the Moon, where the sort of protagonist of that story, who's a very successful businessman, says how he started out just as a runner for a telegram company. And he said he read the terms and conditions on the back of the telegram. And he said, do you know what that actually said? And one of his business partners says, well, presumably in exchange for this, we'll deliver the telegram. He said, no, it says nothing of the sort. It just sort of says, in exchange for this, we'll have a go at delivering the telegram, but we don't promise anything. And he says, and I've kept that with me ever since as the finest piece of print in existence. And there is a lot of that. I mean, politicians are good at manipulating words. I mean, it's not that long ago that the most popular profession for MPs was barrister. And we are manipulators of words. That is our job. We look for quirks of language and phraseology, in the same way that advertising executives do. But yeah, so there you go. I mean, basically, no matter what they say, there are currently no grounds for bringing a claim, whether it's for breach of contract, for voting for them, for promissory estoppel, because, had they not promised this, you would have voted for the other guy, or just for legitimate expectation, because it's just made too generally just to count for you. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. Where am I today? I'm up at Tresillick again, at the head of the river, and I'm actually hiding under a tree. I personally don't mind walking around getting wet, but the camera isn't too keen on it. But I'll pan round so you can see a nice view of the river and some incredibly noisy geese. I hope that's not a commentary geese on, my comments or my fantastic talk about judicial review and contract and promissory estoppel. But there you go. I should have come up here at high water. It's ironic, isn't it, that it's absolutely siling it down, but the river's empty. But anyway, I've scared all the geese off now. There you go. Hope you found that useful, and now I'm going to go find somewhere dry to edit this.